Hey, everybody. Good morning, good afternoon, good evening, wherever you are here live with us or on replay. It's Kathy, and just wanted to spend a little bit of time today in this live going over some content that we've really focused on over the past couple of days having to do with Mr. Kohberger's petition for post conviction relief. As you know, he filed just under a month ago. It was docketed the 27th of July, and he is looking to have his guilty plea and his sentence and his conviction set aside. He's given three basic categories of reasons or grounds for the same. He's saying, number one, that his guilty plea last year was not a product of his own free will, that he was coerced. He's also alleging that there was what appears to be egregious violations of ineffective assistance of counsel, which is a Sixth Amendment privilege that a person who's arrested and appointed counsel has to have effective assistance of counsel and assisting them as they navigate their way through the judicial system. And then he is as part and parcel to the ineffective assistance of counsel claim. He's saying that there was key information that was withheld from him. And the example that he's given is that he's stating he was not told about some potentially exculpatory. What exculpatory means is evidence that would tend to be helpful to a defendant. The opposite of inculpatory. Inculpatory would be evidence that would be not helpful, that would tend to point in the direction that this person committed the crimes. And he's saying that there was some important exculpatory evidence, and he gives the example of of hair, clumps of hair that was in one of the victim's hands that he was not told about. And it's not an easy thing to do. He's pled guilty. He stood up in open court on July 2nd and pled to the 5 counts that he was supposed to stand trial for that were set forth in the indictment. And we've really been focusing on one of the counts that tends to get overlooked, count one, which is the burglary count. It's, I think, massively important. And I wanted to spend a little bit of time on that count because I think that there may be some evidence here and some information that will help him as he attempts to navigate his way through post-conviction relief. But wanted to welcome, we've got some folks here live. We have Chihuahuas in Crime, who was first person here. Want to welcome to we're here live in chat today. We have New Orleans lady, hi, from the great state of Louisiana, who's joining us. We have one of our I'm grateful for members of our channel, Baby. Good morning, with a big happy sun sign next to Baby. Are you anywhere in the Sun Belt? Is it sunny where you are right now? Pretty much Finland. Are you joining us from Finland? If you are, let me know. You know, I know that there are people that have followed this case, not just across the country, but across the world. It is, I believe, one of the biggest true crime cases in the recent past, having to do with the unalivings of 4 University of Idaho students who were found in a home that was steps away from the college where they were attending class, pursuing their dreams of getting a degree. It's something that as parents, we all dream about for our children, as grandparents for our grandchildren. And it captivated the globe's attention when the case first broke in November of 22. And then approximately 6 weeks later came the announcement that Brian Kohberger had been arrested for those crimes across the country in Pennsylvania. Big case. I think it's going to be massive as it moves through post-conviction relief. And it's a case that certainly captured my attention from the moment that I started reporting on it when I did the Idaho versus Kohberger podcast, where we looked at every single document as the case was going along in real time. And we recently ended it when Mr. Kohberger went into post-conviction relief. It's over 1,000 episodes that operates almost like an audiobook of the case, and it's available here on YouTube. And what I like about it is it has a search engine. So if there's one specific area of the case that you're interested in, like IgG DNA, or maybe you want to find out about how the indictment came about, or how it was that the case moved from Latah to Ada County, the transfer motion, you just plug it into the search engine. It'll pull up the episodes, and the episodes will tell you in 5-minute or less episodes, down and dirty, what the motion's about, what the event is about, and where you can find it on the docket. Now, we have quite a few more people that have joined us. We have Alpha Madness. Hi, thank you. Thank you for being here. Isles of Shoals, long-term subscriber to our channel. I know that you're very interested in the Kohberger case. And Pretty Much Finland. Yes, I'm in Finland. I saw a beautiful video. I showed it to my son because he's very much interested in the Northern Lights. They just went to Alaska and were hoping to see it, and they didn't. And there was just this video of the Northern Lights from Finland. I guess it was taken maybe last December. That was just spectacular. Have you seen them where you live? Pretty Much Finland. Good morning, Yvonne. Thank you for being here with us. And we have another member of our channel, William Tardy. Thankful for you to be here. Thank you for being a channel member, William. And we have Marley. Good afternoon. Where are you that it's afternoon, Marley B24? And Kathy Rutledge, one of my longest term supporters. Kathy's been around almost since day one and has supported me down through the years as we've reported. First case that I reported the true crime genre was Idaho versus Kohberger, and we're continuing to have it be a major case that we're following, but we're also following, for example, the some of the appeals, the Schofield versus Giard, that's the Idaho 4 defamation case, where a content creator was ordered to pay $10 million in damages to a University of Idaho professor based on some content that she had published. That's on appeal in the Ninth Circuit Court of Appeal. We're also following the Delphi appeal that's out of Indiana that's getting ready to go to oral argument. And Mr. Allen is hoping to get the 2 convictions set aside in that appeal. He's got some really compelling arguments there. Will he be able to get the conviction set aside or not is the question there. We're reporting on the Pamela Smart case. That's another post-conviction case that's out of New Hampshire. And that is one of the first, I think it might even be the first gavel-to-gavel true crime case that was shown on television back in 1991. And that case dealt with, she was 22 at the time, and she was employed at a high school in New Hampshire, got involved with a 15-year-old student. The 15-year-old student wound up unaliving her husband. And she was brought up on charges that she was the mastermind behind it. She's been in prison now for more than 3 decades. She's tried many times to get the conviction thrown out. She's been unsuccessful. And she had a post-conviction relief action that she filed. And we're waiting for a ruling on it. That's the Real Life to Die For case. If you've seen the movie with Nicole Kidman, who starred on it along with Joaquin Phoenix, who played the teenager. Very, very good movie. And so we're following others. Kathy's wondering, when do you think the judge will make a decision? Kathy, I think that we're waiting for the amended petition to be filed. See, what we have right now, we have a situation where Mr. Kohberger, as a pro se party, he filed the handwritten petition for post-conviction relief. And I think that if everything he's saying there is true, of course, there's 2 sides to every story. But if what he's saying is true, I think he has a good opportunity at getting post-conviction relief. but it's not in the form that it needs to be. It's got to be in a form where he's citing to case law, where he is attaching more, although he did file his own affidavit. An affidavit is evidence, it's sworn testimony. You need to have the attorney come in there and clean it up to make it be in the best possible light for him that cites to the appropriate law that includes more facts and argument. And we're waiting for that to be filed. And then once that's filed, then the judge could summarily, if Judge Hippler feels that it doesn't rise to the level of what it needs to be for post-conviction relief, he could dismiss the case. I don't think he will, just based on the fact he did appoint him counsel, and he could have easily dismissed the case just based on the pro se filing. Sometimes pro se filings are dismissed, and attorneys are not always appointed, particularly in Idaho. So I think we're going to wait for a response from the state of Idaho. It's not going to be the Latah County prosecutor. It will be the Attorney General's office. Attorney General Labrador has already stated that he intends to fight this, do whatever needs to be done to ensure that the convictions stand. And then what Kohberger is hoping for is to get to what's called an evidentiary hearing. And that'll be a little bit down the line, and that could be quite compelling. Imagine seeing Mr. Kohberger in court and seeing people possibly taking the stand to give live testimony, or it could be done in affidavit form, but just imagine live testimony. Imagine seeing Ann Taylor, Bill Thompson, the likes of Detective Brett Payne, Mr. Kohberger himself taking the stand at a potential evidentiary hearing. We're waiting for that down the line. Written Dreams, good morning. Thank you for being here with us. Yvonne, you're confused as to why Brian asked for a transcript of the sentencing hearing. I know. Yvonne, I've been thinking about that the past few days. I'm wondering if there's maybe already a transcript that's not been published on the docket from change of plea, because change of plea is where the prosecutor basically, after Mr. Kohberger pled guilty, said that there never was evidence putting him in the house. There was evidence of, supposedly, their evidence would have shown him in the area. But we're going to go over the elements of count one in just a minute. But I wondered too why he didn't ask for both. And then I thought, well, maybe there's already a transcript that's just not on the docket. With the secrecy of this case, I wouldn't put it past anything not being in the public domain. But we're going to find out when this amended petition comes out, I think, why it is that he only asked for the transcript himself. It's obviously something from sentencing that caught someone's attention. And by someone, I mean his attorney, who's been appointed to represent him. And I believe that Kohberger is going to be very much involved in this case. I think he learned first time around that he needs to be involved. Hi, Freedom Fighter 77. Good to see you. Good to see you. And we have, Scotland. Wonderful, Marley, from lovely Scotland. I visited, my goodness, many years ago. I had the pleasure of visiting Edinburgh. What a beautiful town to be in during the summer. There was a festival there at the castle. We went downtown. Wonderful people, great food. I'm hoping to return someday. Where are you in Scotland, if you don't mind saying? And Isles of Shoals is asking, can new attorney Rauch confer with Ann Taylor, or are they not allowed to speak? That's a great question. I wonder, I guess potentially he could pick up the phone. He's got to do his research on the case. He didn't represent Mr. Kohberger. And while he might have known about the case, it's one thing to know about a case generally, and then to represent someone, especially in such a complicated, this case went for more than 2.5 years. That docket is massive. I guess he could call, but then, Mr. Kohberger made some serious allegations against her. I wonder if she would pick up the phone if he ever did. That's a real interesting question, though, Isles of Shoals. Thanks for asking. It's unfathomable after all this time to think we might possibly witness that. Yep, freedom fighter, you're right. I continue to say this is the biggest true crime case around right now. I can't think of anything else that rivals it. I've been interested in true crime since the 90s. Basically, I watched the Pamela Smart trial like everybody else did back in 1991. And you could go down through the years. The biggest cases in the United States, what were they? O.J. Simpson. It doesn't hold a candle to this case. You could get into the Long Island Lolita case. You could get into the Menendez brothers. You could get into the Watts case. You could get any of the cases down through the years. I can't think of anything that rivaled this one, especially with the constitutional issues. We're dealing with a case that was so highly secretive, where trying to report on it was extremely difficult. First Amendment, freedom of the press. I feel that what we do here is the press, that we're operating like especially during the early days of our country. You didn't have these big mass media outlets reporting to the residents and the citizens of the 13 original states. It was small press, and they were watchdogs for the government. They were the eyes and ears. And I like to think that that's what we do. We look and we see where it is. First Amendment took a beating, I think, in this case. And so I think also, then you have Sixth Amendment privileges, rights that are at issue here. 14th Amendment due process clause. A really constitutional theme here. And we weren't there. I don't know if Mr. Kohberger was involved or not. I can't say it. I wasn't present, but the way that they're fighting to keep this case under seal, and now when we're really taking a strong look at count one, the elements of the first count, and some of the things that have happened, the lack of evidence, you got to wonder, why was he even arrested? I'm really starting to wonder that. Hey guys, please leave. Kathy is saying, hey guys, please leave your DNA on the like button and support the channel so much. It's free. And so, yeah, please subscribe. Thank you, Kathy. Thank you, everyone. Please, if you could hit the like button, it really does help our channel grow. We're trying to get our word out as an alternative to mass media, who just only really looks at, in my opinion, the prosecution's case for reasons I don't know. I really don't. And so we're trying to get it out. Oh, wow. Freedom fighters in Newfoundland. Interesting. I never knew that. And what he said, there's people here in Newfoundland who can't believe how this case is unfolded. So this is a big case in Newfoundland, freedom fighter. That's interesting. Thank you for telling me. Yeah, Yvonne, I agree. This case is in a class of its own in so many ways. Sweet home Alabama, Kathy. Everyone is giving their locations, and it tells me, it just tells me, it confirms every time what I believe in, that this case has captured the nation and the world's attention. Tomboy Charm is saying, I watched a case in 92, 93 that was personal to my family and resulted in a DP conviction. Interesting, Tomboy. And we have Marley. I'm in Glasgow. Yeah. We went to Glasgow as well. It was Glasgow and Edinburgh. We were in both of those towns. I have seen the Northern Lights twice. Wow, just in your garden. Interesting. What a sight. That must be so interesting. Robin Rowe in Idaho. Tom, I pray you got justice. Me too, Kathy. I agree. I agree too. But this case, there is just absolutely no question in my mind that there's true crime cases. They're interesting. They're important. Whenever someone's life is cut short, is a tragedy of immense proportions. I read a survey one time that says when one person is unalived, it impacts 50 people at least, forever. There's no coming back. That's it. And this case, you're 4. And then we have, if people have called it the Idaho 4 case, some people call it the Idaho 5 case. to include Mr. Kohberger and his family. She's still on DP row. Interesting, Tom. All these years later, Jay Harm is saying, keep up the fight. Been following since the beginning. Are you guys going to continue to follow this case through post-conviction relief? You know, we did a survey the other day. I did some research. Mr. Kohberger is at stage 1 right here. He has to go. People have said, why is he going back to Judge Hippler? Well, that's how the statute's written. You have to. He had to file the action in Ada County because that's where the conviction happened, and it has to go before the same judge. That's why Judge Hippler is on top. And if he doesn't get a result that he likes, or if he does and the state wants to appeal, then they could appeal to a higher court, such as the Supreme Court of Idaho. So there is a second phase that could happen, and then ultimately could go out federal to the Supreme Court of the United States. And I did a survey of a case that was in Ada County as well, Garza versus Idaho. Mr. Garza filed his petition for post-conviction relief in Idaho, Ada County, in 2015. It took until 2019 for it to get before the Supreme Court. And the Supreme Court found that ineffective assistance of counsel allows an appeal waiver. He signed a plea deal. He signed away all of his appellate rights, as Mr. Kohberger did. And when there is effective assistance of counsel as to a certain level, like he wanted to appeal his case, and he directed his attorney to appeal, and the attorney didn't, pointing to the post-conviction, the waiver of appellate rights. That took 4 years. So looking at that as a yard, and it could take longer because this case is so complicated and the courts have become very clogged. It could be 6 years before it gets to the Supreme Court, assuming it goes that far of the U.S. Now, I'm seeing here that people are saying, William Tardy is saying yes, intends to follow this case. Someone in some place is opining that Judge Hippler took it personal and was totally biased, in my opinion. Yvonne Poole is saying there was a case in 1986 that affected my family. The 2 people convicted were sentenced to life in prison in Florida. They are still in prison. Sorry to hear that. Freedom fighter Kathy, if everything develops the way it should, assuming BK has substantial evidence to support his claim and the fact that the family support trial, do you honestly think the state would even fight it? Yeah, I think they're going to fight it. I mean, they've said his post-conviction action the ink wasn't even dried on it. It was filed the 27th of July. And on the 27th of July, the AG, the Attorney General of the state of Idaho, by the name of Labrador, said we're gonna defend it. You know, they feel bad for the victims' families, and they say we're gonna defend this case. So I think they're gonna fight tooth and nail. My opinion also, when you challenge the power block, they don't give up easily. You know, you really have to fight and fight and fight. You're dealing with a certain level of arrogance. It's hard for you say, well, you know, come on, you know, give it up, admit what happened here. Sometimes it takes a really long time, if ever, to get to that point. So yeah, I expect there's going to be an enormous fight from the AG's office on behalf of the state of Idaho. Good morning, number 8. Very happy to see you in chat here with us live. And Krista Pike has an execution date next month, September, in Tennessee. Pike has been on Tennessee's DP row since 96. Wow, 3 decades. If Tennessee carries it out, first woman unalived in Tennessee since 1819. Wow, interesting facts coming into the chat. I didn't know that. I'm going to definitely have to research that. Mystic Sin, welcome. Someone in some place, do you think we'll get any new information tomorrow? Well, I'm watching the docket. You know, every day, courts will be open tomorrow, Monday, after the weekend. And I'll jump on a couple of times, 2 or 3 times, now that we have the Kohberger action proceeding, to see if there's anything filed. And if there is, I'll let you know. You know, I'll put out an alert. And we have, okay, whoops, Krista Pike. Sorry, too much Idaho 4 with that. K names, definitely. Hey, Michael, you're from England. What part? I spent some time during my younger years in London. I loved London. It was such a great, great city, massive city. I couldn't believe how large it was. Like I always associated London with being the size of New York or Los Angeles. Oh no, it's many, many, many times. Such a great, great place to be. So what part are you from? All right, so we have 58 people, only 39 likes. Please hit the like if you could. And if you haven't subscribed to the channel, please do, because we're going to be putting out a lot of new content in the next week, really looking at this Idaho 4 case now that we're in post-conviction relief stage. Oh, Derbyshire. Okay. I would like to thank everyone in the chat. I really enjoyed it this morning. Thank you, Miss Kathy. Kathy, yeah, I'm really glad. I'm very happy. We put up some content yesterday regarding did the prosecutor give Kohberger something that might help him with post-conviction relief. We've got that video. If you haven't, we've got it pinned in this chat. Please take a look. It's the last one that we did. I mean, you can find it and I was really happy to see a lot of conversation. That's what our channel is all about. Our channel is about the First Amendment and being a place that welcomes viewpoints, opinions, serious opinions, not fighting, not calling people names. We're not going to tolerate that, but good discourse. And we got it. We had a lot of people who started to look at this count one in a different way. And that's what I was really hoping for. And I pinned to that video, one of our followers asked a question. Okay, Chad, how do you feel about defense counsel? Did defense counsel represent him or not? What's your opinion? And I like to see those conversations going back. I read every single one. If you're going to take the time and effort out of your day to write something, the least I can do is take a look at it. And so I really, really enjoyed that. And Kathy, I saw you were commenting, and always appreciate your comments and everyone's. I think it's very, very respectful of the First Amendment and of everyone's opinions, especially on a case this big, a case this important, a case that could have some real ramifications on our Constitution and how future cases. I mean, if a case this big with so many eyes on it could go for more than 2.5 years, be as secretive as it has been, is this the precedent that we want to set in this country? I'm very fearful about that, and that's another reason why I'm following this case. And Tomboy Charm, didn't Thompson say at the press conference after the plea hearing or at the plea that they could never? Yes, I mean, he said that many times. And that's after he pled, before and after he pled guilty, which is astounding to me. It is astounding to me that he would ever bring the charge of burglary without having some proof that he was in the house. And I want to go over the burglary count with you. This is a good segue into what I wanted to do. If you look at the case, and we have to go back to the very beginning, December 29th, 2022, there were 4 filings. The initial filing that started everything was the 18-page affidavit of probable cause signed by lead detective for the Moscow Police Department, Detective Brett Payne, which ended with Detective Payne asking for the warrant for Mr. Kohberger's arrest based on everything that was set forth in the 18 pages that preceded it, feeling that he was a good suspect. He was a defendant here in the case. And then what happened? The second item is a criminal complaint. We published it. We've got the document in the last video that we did. Page 1. It was signed by Bill Thompson. And a prosecutor should not bring a case where there's not evidence. And you don't have to bring it beyond a reasonable doubt, not at that stage, but at least that there's probable cause to believe that this person committed these crimes. And if I look at count one, which a lot of people and it's easy to jump to 2 through 5. Those are the counts for unaliving. Maddie, count 2, count 3, Kaylee, count 4, Xana, count 5, Ethan, that brought with it the potential for the DP. It was not count 1, it was counts 2, 3, 4, and 5 that caused the state of Idaho to seek the DP when this case was in pretrial for the more than 2.5 years that it was. And it was the DP that was taken off the table. That was what people understood. Mr. Kohberger was concerned about the DP. He was worried about his chances. So he entered into this plea deal. And we find that there was, when that bomb hit on the 26th, and we got to read his at first out-of-court statement, along with the affidavit and what the post-conviction relief said, I'll tell you, it made a heck of a lot more sense than what I was seeing. I tried for almost a year to look at that docket because I was shocked when I found out that he had entered into a plea when news of it broke. I said to myself, what case are they talking about? It can't be Idaho versus Kohberger. It just can't be. And I remember watching the proceedings on July 2nd. I still couldn't believe it. I had to pinch myself. Am I seeing what I'm seeing here? He's standing up in open court and he's pleading guilty to these 5 charges from the indictment. That's what he was supposed to go to trial on. Hey, Michael, first heard me on Dagger. I thought then I liked, okay, I'm glad. Hey, Callie, good to see you. Good to see you. Thank you for being here. And so we see, I'm sorry, I don't believe anything Bill Thompson has said. He lies, is Kathy Rutledge's opinion. So getting back to the beginning of the case, day 1 of the Idaho versus Kohberger case was December 29th of 2022. And that was when the affidavit of probable cause, then the criminal complaint. This was sworn out by Bill Thompson. And it says, first line, based on the affidavit of probable cause, we believe that a warrant should be issued for Mr. Kohberger's arrest, and he has committed these 5 crimes. Count 1, burglary. Count 2, unaliving of Maddie. Count 3, unaliving of Kaylee. Count 4, unaliving of Ethan. Count 5, unaliving of Xana. And he cited the statutes. These are violations of the laws of the state of Idaho. Hey, Satire, this could be me. You're right, absolutely. This could be anyone. This could be me. It could be my neighbors. It could be you. We are citizens with constitutional rights, and if we don't fight for them, they're not going to be here. It's the bottom line. And what gets me is that there have been some content creators who have been very, very hard, not just on Mr. Kohberger, but on other people who want to see the evidence as being pro-burgers or, just bleeding hearts who want to see unalive, vicious criminals be let out on the street. How would we want Mr. Kohberger to come to our house? No, it's the point that then you see them, anybody. I mean, who here amongst us can say we've never had a family who's never been in trouble with the law? We haven't had maybe a spouse, a significant other, a friend. I doubt that anyone could escape that. And when it comes to some of these really hard-liners, when it comes to other people, when it comes to the like of Mr. Kohberger, when it comes to the like of some of the other defendants in cases that we have followed, such as Mr. Allen, they're guilty because they've been charged with crimes. But when it comes to them, there's a content creator who's charged with a crime right now in Florida. There are other people who are really hard on others who have been charged with crimes and don't feel that they should have due process. But when it comes to them, or their brothers or their sisters or their family members, I don't see them saying, hey, I'm guilty. I've been charged with a crime. Okay, sentence me, judge. Oh, no, no, no. They want their due process privileges and they're going to fight it. Hey, Witchy Watch, welcome. They're going to fight it. So what are you doing? Fighting someone else who's on trial for their lives of demanding due process, or anyone else who's watching this case who demands due process. If you know that if it were you, your family member, your spouse, your brother, your loved one, your neighbor, you would demand that they receive due process. This is about the Constitution. Hey, Christy, good morning. Good to see you. This is about the Constitution, period, end. And I'm so happy that Sata, she reminded us, this is why I'm following this case, because of the concerns that I have of the beating our Constitution took. Hey, Deborah, thank you for being here. Thank you so much. So let's take a look. I want to go back to count one. So we had the start of the case was December 29th, 22. We have the affidavit of probable cause signed by Detective Brett Payne, 18 pages, asking for the warrant. Look at the last page, tells you everything you need to know about how important that document was. I don't want to hear that it's irrelevant. I don't want to hear that it doesn't mean anything because they got the indictment. They wouldn't have gotten the indictment without that affidavit of probable cause as the foundation of the building of this case. Without that affidavit of probable cause, we might not have even known who Kohberger is. Very, very important document. So then we have Thompson charging Kohberger with all 5 of the crimes that he would ultimately was going to stand trial for last August, but didn't because he changed plea to the shock of many, myself included. And he asks basically the judge to enter to find probable cause, enter the order finding probable cause, which Judge Marshall did, citing to the affidavit. They're not bringing in the evidence. They're not bringing in the video of so-called suspect vehicle 1. They're not bringing in the sheath. They're not bringing in so-called DNA results. They're not bringing in the phone pings. They're not nothing. It is based on the PCA. That is all that she has in front of her. That's how it works in this country. And that's why it's got to be done under penalty of perjury, because you're looking at potentially taking someone's life, liberty for sure, away from them. It's got to be accurate. Do you think the PCA is accurate? Mr. Kohberger called it a work of fiction in his first and only statement to the public. He called it a work of fiction. He said the entire case is fiction and it's never been challenged and it needs to be challenged in a court of law. And that's why he wants a trial. We're seeing number 8 feels yes, the affidavit of probable cause is a work of fiction, agreeing with Mr. Kohberger, I believe. And Lauren Jean, thank you for being here. Good morning. Good morning. So she did find probable cause based on, she's got the complaint from Thompson in front of her. She's got the PCA in front of her. She finds probable cause based on the affidavit of probable cause. And then what's the next thing that happens? The warrant is issued for Mr. Kohberger's arrest. And then there you go. Everything with that warrant. Then they arrest Mr. Kohberger. They go into his family's home. They pull him out. They take his car. They seize property from his parents' home in Pennsylvania where he was staying. They go into his apartment in Pullman, Washington, where he was living. They search and seize things from that apartment. They then go into a storage facility that he had at the Steptoe Apartments. They search that. And then they issue all of the warrants that were issued starting in January, February, AT&T, and everyone else. They do that because the criminal case was opened. And it all started with the affidavit of probable cause and that criminal complaint. Now, let's go back. We keep jumping back and forth, but I want you, if you could, just consider what this first count says. Okay, we're going to go through the building blocks a crime such as this crime of burglary that he was charged with in the criminal complaint by Bill Thompson, December 29th, 2022. You think of the building blocks, the elements of a crime, like elements of let's say you're making a cake. How many people in chat have ever made a chocolate cake or eaten a chocolate cake? You know, boy, oh boy, I wish I had some chocolate cake right now. It sounds very, very good, some chocolate cake. If you've made chocolate cake, or you've been around, maybe if you're, you know, a parent or someone else is making it, the chocolate cake just doesn't appear out of air. There are elements. Okay, here we go. We got Soren, who says, under Idaho 185411, any person who uses willful perjury or subornation of perjury to cause the conviction and is punishable by unaliving. Interesting. Some states have that. I didn't know that Idaho did. I got to do some research on that. Thank you for bringing that to my attention. William Tardy, he's got his hand up. You've had chocolate cake. I would love some chocolate cake. Well, chocolate cake, as we know, does not appear out of nowhere. You need ingredients. There are elements that go into making a chocolate cake. What are they? Eggs, flour, butter. Let's say some people might put a little bit of oil into it to make it, you know, moist, or some milk or some water if you don't want to put oil in it. And you need chocolate. Without, let's just say, take away flour, you don't have a chocolate cake anymore. With just chocolate, you might have something else that's chocolatey, but if you put in chocolate, eggs, oil, milk, butter, you mix it up and you put it in the oven, it's not going to make a chocolate cake. You need the flour to make it rise into a cake, right? That's an element of it. Now let's look at the elements of burglary. That was count one. We got to look at count one. I'm going to spend a lot of time in the next couple of weeks dealing with count one. If you look at the indictment, remember, there was supposed to have been a preliminary hearing where the state of Idaho was going to go into open court and show their cards, show their evidence to bind Mr. Kohberger over for trial, because when he was arrested, it was on the power of the PCA and the complaint that led to the warrant for his arrest and the finding of probable cause, of course. Count one of the criminal complaint signed by Bill Thompson, December 29, 2022, that when he convened the secret grand jury in May, he came out with a document that looked very much like that criminal complaint. All five of the same crimes with the elements for each one. Let's look at, if you look at count one, you're going to see section 181401. That is the statute that prohibits burglary, that makes burglary a crime in Idaho. Count one, burglary defined. Every person, element number one, who enters any house, room, apartment, and there's other physical locations. I'm not going to read them all. Every person, element number one of burglary, who enters any house, etc., etc. Element number two, with intent. Element number three, to commit any theft or any felony. Element number four, is guilty of burglary. Now, take away one of those elements. Take away every person who enters any house. Let's say it's a dog that's chased after someone, and the person runs into a house, the dog runs after the person and intends to commit and jumps on the person, bites them, harms them. Well, a dog's not a person. Can't be burglary. Now, count two, or element number two, who enters any house. Gotta enter the house in order to commit the crime of burglary. It is the second element. It's like that cake. It's like you need flour, element number 1. You need chocolate, element number 2. You need butter, element number 3. You need oil, element number 4, and so on to make a cake. You take away the flour, you don't have the elements of a cake. So again, 181401, burglary defined every person, element or ingredient number 1, if we want to compare this for exercise purposes to that cake. Every person, element or ingredient number 1 of burglary, who enters any house, etc. Element number 2 about burglary. With intent, element number 3 of burglary, to commit any theft or any felony. Element number 4 of burglary, is guilty of burglary. This says this is what burglary is. It defines burglary. Now you tell me where the prosecutor ever had any evidence that Mr. Kohberger, yes, he's a person. He's a person. He's not a dog. He's not a chicken. He's not a stool. He's a person who enters any house. Where is the evidence to show that Mr. Thompson in good faith brought that first count? He told us in January at a hearing that they couldn't place Mr. Kohberger in the house. This is January of 23, after the criminal complaint had been filed, where he's saying, I'm charging you, Kohberger, with 181401, burglary of this property. He went in before the grand jury and he brought those 5 counts again, starting with count number 1. He's made comments in Latah County that Mr. Kohberger didn't stalk anybody. There were all of those so-called rumors that he did. I'll tell you where it started. It started in the PCA, because what Payne did in that PCA is he said he needed warrants. They had issued one because they wanted to see if Kohberger was stalking either any of the victims or any of people in the inner circle, close friends, family members. Then a change of plea, July 2nd, 2025. Kohberger stands up. Judge Hippler, it goes through the element of burglary. Do you admit that you entered 1122 King Road with the intent? That means a plan beforehand at the time that he entered that property to commit a felony. He said yes. He's going through the elements of count 1. Take a look at the sentence. Take a look at change of plea. You'll see when Judge Hippler does that, and you'll see how Kohberger responds. But even after Kohberger did, then Thompson stands up and he gives a recitation to Judge Hippler, to a counsel for Mr. Kohberger, who's representing him. All 3 of them are at the table with him, and the world. And he said, well, we've got evidence that, with these phone pings and whatnot, that he was around the area, that he was in the neighborhood, he was in the general area. It's not good enough. You can't commit burglary of a house if you're not in the house. The clear and unambiguous language of count 1 says that. So why was he ever charged with this count? And why didn't somebody jump up and down when he said that and not just that, but also he said, oh, we don't think that he had the intention to unalive all 4 of the victims. He encountered Xana, not that he went in there with the intention to do harm to. He encountered Xana. Then why are you bringing count 1 against Xana? Because it doesn't fit that interpretation. We went through that in the video yesterday. You'll see where that. So, hey, Blueberry, good to see you here. And we see here they're all based on stipulation that he entered the house. I get it, but when did that happen? They're all based on the stipulation. They're basing it on he signed that plea agreement. But that plea agreement was signed when? June 30th, 2020. What happened? they needed to have at least evidence to ever bring that count. I'm saying at or before December 29th, 2022, because that's when he was charged. Without having some piece of evidence putting him in the house, they should have never charged him with burglary. Count one. And what's count one say? With the intent to commit another felony. What are the other felonies? The other felonies happen to be count 2, 3, 4, and 5. So if he never entered the house and he never had the intention to did he commit any other felonies as well? I mean, everything begins and ends with this count one. So I'm going to be spending a heck of a lot of time researching other post-conviction relief actions where burglary was brought forward to see what happened in those cases. Written Dreams is saying, but Brian, if didn't enter the house, then the first thing is already missing. No chocolate cake. Exactly. Written Dreams, that's exactly what I'm arguing here. The elements of a crime are like the ingredients of a recipe. Chocolate cake. You don't have flour. You don't have a chocolate cake. It's not a chocolate cake. If the person didn't enter the dwelling or the house and you don't have proof, and it is the state's obligation to bring forth that evidence, you don't have a burglary. So what did he plead to? He pled to something he didn't do. That's what he's saying. What's he saying in post-conviction relief? I pled to something I didn't do. I'm innocent. I was forced to do it. I was coerced. I wanted to go to trial, right? I wanted to go to trial. I pled to something I didn't do. First charge, satire, her opinion. Satire is saying first charge unsustainable. And that's like the PCA. Count one is the foundation for everything. Everything that he was supposed to stand trial for. Without that burglary count, if they didn't have evidence and he did not enter that dwelling with the intention, meaning they call it the mens rea, in his mind with malice of forethought before he ever stepped foot in 1122 to commit these other felonies, everything falls apart. Everything falls apart. Yes, Tomboy Charm, that's why the burglary charge was relevant. That's why I say everything begins and ends with the burglary charge. Just like I've been saying for years, don't tell me that the PCA is irrelevant, Mr. Thompson, because the PCA is the foundation of the house. Without the PCA, you're not going to take out a criminal complaint because you cite to the PCA. You're not going to go to Judge Megan E. Marshall with that PCA and criminal count and ask for probable cause to be found, which she did find, and you're not going to get the warrant for his arrest. And everything else that the warrant for his arrest allowed for. It's the foundation of the building. Count one is the foundation for everything that he was charged with. Yvonne's saying here, so in reality, the burglary charge was the most important charge in order to bring the other charges. Hey, count one appears before everything else. Different story if it was counts just 2, 3, 4. If it was count one, unaliving of Madison, count two, unaliving of Kaylee, count three, unaliving of Xana, count four, unaliving of Ethan, bringing with it the potential sentence of the DP. Now, some people have opined that these crimes took place somewhere else. Some people think it happened at the Whites. Some of the crimes might have happened. Some people think it might have happened in the backyard. Maybe not all four of them, but some. Some people think that the crime scene was staged. The people were harmed outside and then brought inside. But that's not what the state's saying. The state's saying everything happened inside that house. So he couldn't have touched a hair on anyone's head, according to the state, without entering that house. Do we see how important count one is? We see how important count one. Count one is the foundation of this entire case. So, with that thought in mind, do you think that this may be the key to him getting post-conviction relief? Callie saying, hey, count one is a big, capital, big problem for the state, 100%. Number 8 saying exactly. Okay, Blueberry the Great saying if we're baking a cake, this is injustice pie. Very true. And I told you the words of Bill Thompson are going to come back and bite him in the butt. Tomboy charm, you were accurate, I think. Tomboy, because remember, he's saying if we go back to what Mr. Kohberger said, he has never spoken. I mean, for a year, we heard not a peep out of him. Everybody was, oh, he's going to do an interview. He's going to do a book. He did nothing. He said nothing. Neither did his family, with the exception of his one sister who sort of gave an interview, but really didn't talk about, spoke in terms of the victims and how badly they felt for what happened, but didn't get into the elements of what, if she was present. He's saying all 4 of his family members were present at meetings with defense counsel. So I'm anticipating affidavits from all 4 of them. None of them said a word. Kohberger never said a word, but when he did say a word, he's raising miscarriage of justice. That gave us the hint that he knows about Hunter versus U.S., which is the June 18th, 2026 Supreme Court case that says if you could show a miscarriage of justice, that would throw shame onto the criminal justice system. If this appeal waiver is allowed to stand, then that appeal waiver should be set aside. The court should not enforce it. Now, that's a federal case, yes. But he cited to it. I think he thinks it's important to his case. What do you guys think? Oh, Suzanne, welcome. Happy Sunday to you as well. Soren saying, I think aggravating factors 2 and 5 could but he didn't plead that. People have been saying, well, what about aggravating factors? Where is that shown in the indictment? Anything about aggravating factors? Doesn't say it. Saying that he committed these crimes with malice aforethought after entering the property. Some people have said, this could be felony. It could be, but he's not. He wasn't charged with felony He wasn't charged with felony unaliving. There were no that what was in the indictment later on. What they did is they showed it for purposes. There were aggregating factors to get the DP on the table, but not with the charging instruments. Not with the indictment is what he was going to stand trial for. Judge Hippler referred to the indictment, the change of plea. There is nothing in there for felony. It was first degree. That's it. Tomboy Charm is saying Cy Ray always had that data. If he truly was in the house, you can rest assured the state would have screamed. Yeah, I agree. And what about his affidavit? I give Cy Ray, I'm sorry. Cy Ray was supposed to be his alibi defense, part of his alibi defense. And now he's going around screaming from the top of the rafters that BK is guilty. Well, why were you going to go? Well, explain your affidavit that you signed under penalty of perjury that said he wasn't anywhere near the house, that he was at Waiwaiwai Park. You were going to get up on that stand in front of that jury as part of his alibi. You understand what that means? That means telling the jury that it couldn't have been him because he was somewhere else. He wasn't just an expert witness. He was part of his alibi. And then we got Bexter 2, the burglary charge, as well as ineffective assistance of counsel, will get him a new trial. Witchy wash. Come on. They would have screamed it from the top of the rafters. And why aren't they showing the interrogation video from when he was first arrested? He literally, pulled out of the house, taken down the road to the Pennsylvania State Police barracks, goes into a conference room, sees Brett Payne and his colleague from the ISP. Those are the only 2 people who interviewed him. They will not release that 45-minute video. What did Kohberger say? What is it that they're afraid of releasing to the public? Come on now. It's almost 4 years. That's one of the first things they do. Law enforcement loves to show off how they outwitted and outsmarted the defendant. They will not. They are fighting EWU media who want that and everything else. Kathy, okay, go lie down. Thank you for being here. Thanks for being here. Okay, Itty Bitty Poop is saying, if you're a liar, hurting others as equally as you accuse others, you'll always be made a fool of by God sooner rather than later. I prefer sooner. Baxter, then IGG will be thrown out for chain of custody issues. No IGG, no. Please, that's such a sore point with me, Beckham, too. I did a series that I called 3 Days in Moscow that went over the chain of custody of that sheath, beginning with why the heck didn't that sheath get taken immediately to the Idaho State Police lab in Meridian? Why was it given instead to Brett Payne outside of 1122 to do whatever in the dark at like 12:10 in the morning of Monday? And then the regular evidence person happens to be out on vacation that week, has to call ISP for help because they're trying to fill in for somebody else. And then you got two people from the ISP who one person shows up, supposed to be taking the sheath to Meridian on day, was it the 16th? Stops along the way. We don't even know if that's approved. Turns it over to, what do you do? Stop at McDonald's somewhere and left the sheath in the trunk, goes in, gets a Big Mac, comes out, gives the other guy the sheath to take. I mean, there's just so, and then it doesn't have evidence tape around it. And then the names are sus. It's just, I don't know why they didn't try to get that sheath thrown out on the suppression motion or in limine, like any other, in my opinion, again, this is my opinion on any other defense attorney is going to try to get the star piece of evidence thrown out if they've got questions about chain of custody. And in my opinion, I thought they did. Hey, Melba, thank you. If BK was to speak and question any and all that he thought was wrong with his case, they would have made up a new evidence and attempts to railroad him, in my opinion. Satire, BK PhD student of criminology. He had to have studied Dr. Turvey's work in the past. Baxter is saying, I believe you may have to go all the way up to SCOTUS to get it. That's a good possibility. You know, either side. Let's just say Judge Hippler gives him a trial and he's acquitted. Then you got the state possibly who's going to be going to the Idaho Supreme Court and ultimately SCOTUS. And we looked at how long it took Garza in the Garza versus Idaho case that Hippler spoke about, ineffective assistance of counsel case with plea waivers, 4 years. He didn't get a trial though. 4 years to go from Ada County to the Supreme Court of Idaho, where he was told no both places, finally to SCOTUS, where he got a yes. Took 4 years. So you got a long, whichever side, however things get ruled on, one side's going to be upset. I think they're going to appeal. All right. So sit back. There's going to be years of litigation in this case, I believe. Deborah's saying, if Cy found proof of Brian's guilt, would he be allowed to inform the prosecutor? No. What he should have done, Deborah, because it's not like, that's a great question. He's brought on as an arm of defense counsel. Defense counsel went out, found Cy came, however the heck it happened. He's working for Kohberger. In my opinion, if he at some point felt that, especially since he was supposed to be part of his alibi defense, if he felt that Mr. Kohberger did these crimes, he should have withdrawn from the case. He should have not stayed on the case and continued to access confidential information, pretending that he was still a defense witness. I can't wait I hope that we have an evidentiary hearing, and I hope that Cy is on the witness list to come before Judge Hippler, who is no fan of Cy as we know. Judge Hippler very rarely lost his cool in this case. He did it twice. He did it when the debacle happened with the Dateline episode, and you could see he was upset, and you could see in the orders that went out he was upset that information got out despite the non-dissemination order. The other time is in court when he's speaking with Ann Taylor regarding Cy affidavit and his so-called conspiracy theories. Judge Hippler is the trier of the law. Cy not getting on that stand. I don't think, Kohberger's not going to hire him for this part if he gets a trial. I doubt he would. but he might not have even been on the stand first time around, because Judge Hippler, as the trier of the law, he's got to go through a process and make sure this isn't junk science, because this is not a fact witness who saw, who heard, who has actual knowledge of something. This is a so-called expert witness who's going to try to get in front of the jury and use expertise. That's why Hippler said in the orders, I want your expert report needs to be exchanged by January 23rd. You got to have the curriculum vitae or the resume and what the person's going to testify to, because ultimately nobody gets before that jury until Hippler says, yes, they're an expert. Got to find the expert. Satire is saying a sheath is not a weapon used in the commission of crime. Well, the other thing is, without showing that Kohberger entered the property at 4:07 or whatever time it was, breached the property, the doorway, walked in, wherever, they're sort of inferring that it was the second floor backslider. There's no evidence on the record that the sheath was dropped at that time. That sheath could have been in the house before. Sheath could have been. Let's just say that Cy Ray's right. Maybe Mr. Kohberger was in the property before. Well, maybe he dropped the sheath at that time, or somebody else had the sheath, or that sheath belonged to somebody else. Somebody bought it at a garage sale and it had Kohberger's just 10 miles away. Who knows? You got to be able to show that the sheath was brought in and dropped after 4:07 a.m. Can't do it. Can't do it. Colin, good morning. We have some more people coming in. Please, if you could, hit the like if you haven't. Oh boy, we're getting close to 100 likes. We need 100. We need 100 to get ourselves in the algorithm. It'd be really helpful if we could do that before we end this chat. Please, if you haven't hit the like, do it. If you haven't subbed to the channel, please do. Please sub and hit the notification buttons, because I guarantee we're going to have some more research for you regarding this a forthcoming petition for post-conviction relief action. We're going to talk some more about, as I say, count one. I'm going to be looking at other post-conviction relief actions in Idaho that deal with burglary charges. If we can't find it in Idaho, we'll find some other states, and we'll present that to you for your conversation and your consideration. Yvonne's speculating that attorneys may be waiting to see if Brian's PCR is successful and gets a trial, then one may step forward. You bring up a good point. Rauch is only appointed for the post-conviction relief action. That's what the court order from Judge Stephen J. Hippler said. It said that yes, you get court-appointed counsel, Mr. Kohberger, for the entirety of the post-conviction relief, however far it goes, but not the trial. If Mr. Kohberger gets the relief that he's looking for, a trial, Rauch is not appointed for that. And you might see some big private counsel come in, want to be able to really make a name with this case. If he's able to get his convictions thrown out, Yvonne, I wouldn't be surprised if that at all happens. Hey, Reigning Rebecca, welcome aboard. Yes, Satire is saying the state's key piece of evidence is a movable object, and who even a movable object even before law enforcement got there, I would add. You got Payne saying it was found on the right of Maddie. You got the head of ISP crime scene processing, Detective Talbot, saying it was on the left side of Maddie. There's a note that Talbot wrote that it was on the ground. Then ISP takes a photo after the students are removed. The sheath somehow jumps back up on the bed. How'd that get there? You're telling me the sheath didn't fall? Let's just say the sheath was under Maddie. Maddie gets removed. The blanket gets removed, but that sheath stays there. What? Did the perpetrator take the time to crazy glue it to the bed? You got to wake up very early in the morning for people who follow this channel, because people who follow this channel want to see the evidence. They're not afraid of reading the documents, perfectly capable of making up their own minds. And when things just don't make sense, like why did you ever bring count 1 in a criminal complaint December 29, 2022, if you're saying years later, post-sentencing, that you don't have evidence of him being in the house? What the heck? He's saying he pled guilty to something he didn't do. Why didn't Judge Hippler stop something right then and there? Why didn't they jump up and down, the defense, when Thompson said that? I don't understand. These are just my opinions, and maybe we'll find out as things get into post-conviction relief a little bit later on. Yvonne is opining if Brian can prove he was coerced into the plea deal. Oh, yes, absolutely. Under the Constitution, this has got a plea of guilty has got to be voluntary. That's why Hippler said, Mr. Kohberger, have you had time to speak with your counsel? Do you feel that you had sufficient counsel? Is this voluntary? Has anyone promised you? But it's sort of like what Turvey said. How do I know what I don't know? Remember when he said, when somebody had asked him the question, now, Dr. Turvey, are you confident that you saw everything that you needed to see? And he goes, how do I know what I don't know? How do I know if something was withheld from me? Same thing with BK. If BK didn't know about certain key evidence, and I'll say even discovery was coming in after change of plea. The defense filed a 24th supplemental request for discovery. It was the 26th of June. They had to have been in negotiations by them for them to be able to sign on the 30th of June or very close to it. And what did they ask for? Well, of course, it was under seal at the time. We only found out when Hippler started the process of unsealing documents, which he has stopped. But then we saw that what the defense asked for was information regarding a star state witness, the DoorDash driver. They wanted Molly McMichael's criminal background. They wanted correspondence between Bill Thompson and Molly McMichael. They wanted correspondence from the G family's attorney and Molly McMichael. And that evidence and any videos, audios of her, that evidence, part of it was turned over on the 9th of July. 9th of July, that's what? 1, 2, 3, 4, 5, 7 days post change of plea. You think that evidence was important to Mr. Kohberger's case? What do those emails between Molly McMichael and Bill Thompson say? Is it possible that they might see eye? Speculation. Complete speculation. Complete speculation. But certainly it had to be of interest to the defense. They would have never asked for that discovery. Did Mr. Kohberger know about that discovery? Was it turned over to him? Now I'm going to tell you I'm going to tell you exactly when I heard him say maybe he didn't intend to commit all of the unalivings, and we don't have evidence that basically puts him in the house. I did a video last year, days after that happened, last July, and it's called "Yes, a plea deal can be set aside. A plea deal, it can be revoked. He can move to set aside the plea deal, and here's how." So I saw it as a problem back then. Nobody else did. I'm wondering if Kohberger thought that he had done the equivalent of an Alford plea. You know what an Alford plea is, where you don't say that you're guilty, but you acknowledge that there's enough evidence beyond a reasonable doubt for a jury to find you guilty. It's still the same thing. You're adjudicated guilty, but you don't have to say you're guilty. Did he think that this was a time, save some time, having learned about DP Row, about this, so-called conditions of what it was like there? that coerced him or got him to plead to something that he didn't do instead of going to trial, which it sounds like he wants to do. All of this has got to come out. All of this has got to come out. Hopefully it will come out. Hey, Penn Dizzy, good to see you. I don't know. Hey, satire. What did Judge Hippler ask her? I think this is going to come back to haunt. At one point, did Judge Hippler or did Judge Hippler not ask Ms. Taylor, not Mr. Kohberger, Ms. Taylor, words to the effect, do you have sufficient discovery that you need for Mr. Kohberger to change his plea? And she said yes. She said yes. There was still discovery that was out there. What? So suddenly, discovery that you asked for days before change of plea wasn't important, and why'd you ask for it if it wasn't important? And did Mr. Kohberger know? All of this is going to come out, hopefully, in the wash here. Yvonne Poole is saying, I have a feeling that Brian may have thought he was offered plea by stating AT told him it wouldn't hurt him to lie and answer yes to the questions Hippler asked. Marley, yes, remember, and absolutely said she was a friend of BT. Now, playing devil's advocate, maybe she was trying to talk her way out of getting a ticket by saying, "Oh, I'm Bill Thompson. I'm the star witness. I'm the DoorDash driver and the Idaho girls, however she put it, unalivings." But maybe there's more to the story. That's what that discovery, I think, would have shown. Soren say maybe BK thought the state had a better frame-up job than they appeared to have. Colin, I agree about Steve. He can't seem to shut up about it. Yeah. Oh, yeah. Yvonne, he looked confused at times at the sentencing hearing. I also take a look at the waiver of constitutional rights. I have encouraged you guys many, many times in the past. He had to sign a multiple page document. He hand filled it out, just like he hand filled out the petition for post-conviction relief. And he's scribbling, he's scrabbling, he's saying that he's got a mental health condition, but he's not under any doctor's care. He's disclosing some medications. Who knows if he disclosed everything? He answers yes, then he scribbles it out really hard. In one page, it was page 3. Take a look at page 3. He scribbled something out that I swear, if you had that form, and you'd probably feel it on the other side, the indentation from the scribbling. It looked like he was confused. His signature at the end looked a little shaky. Why the heck didn't Hippler have him evaluated to make sure? Have a doctor go in. Yes, of course, his attorneys signed along, but none of the attorneys, as far as I know, is a mental health professional, a medical doctor, a psychologist, a psychiatrist. How hard would it have been for Hippler to say, we need to set up an appointment for you to be, I need to satisfy, because Hippler could have very easily said, no, I'm not accepting this plea deal. It was up to him. He had to accept it. But it was like, I call it, where's the fire? They had no pre-trial, no pre-sentencing interventions. They waived everything. And it was like sentencing was a couple weeks. It was like the change of plea was the second, sentencing was the 23rd. I'm like, what hurricane are you escaping that you have to have this so quickly and so fast? Why do you have to rush through this? It's the feeling that I got after more than 2.5 years that this case is sometimes at a snail's pace. It seemed like it was moving forward. Now we have to rush. Colin saying, that happened right before the plea deal. Any connections? Apparently a guy was avenging the Aryan when he set a fire. Oh, I didn't know that. Yeah, I'd be interested in learning about that, because we know that who did Ann Taylor take on? A certain member of the Aryans, right? Who got broken out somebody from the Ada counties being transported to the courthouse. They went. They tracked someone down, a witness. They unalived him. They got caught. And Tyler Mead, she's representing him, saying she didn't have enough time to go through Kohberger's discovery, but she's got time to take. Hippler called her on it. You're taking on a second. And we're finding out she apparently made millions on this case. Millions. Why is it allowed for the state to keep dumping unorganized documents, and why does the defense have to keep it? Well, what the state said is, hey, you told us you wanted discovery as soon as we got it in, so here you go. But yeah, it sounded like it wasn't labeled. If you've ever looked at this, it's like a laundry basket, Rebecca. Imagine you're doing your taxes and somebody hands you, a family member hands you a laundry basket with like rolled up receipts from the past year, rolled up into small balls, filled to the top. And you need one piece of paper. How long is it going to take you to go through that? And that's not even a good comparison, because they're saying that this was millions of pieces of paper, of documents, and video, and the one thing that they needed. Well, what I want to know is, here's what I want to know, Rainey, Rebecca. I want to know if at any time the defense served discovery, a request for production or whatever, saying, produce and cite to every piece of evidence that proves every element of count 1, which is the burglary count, counts 2, 3, 4, and 5. That's done a lot in criminal defense. That's done a lot. You start with the elements of the crime. Count 1, turn over every bit of evidence that said that Mr. Kohberger entered the property with the intent to commit another felony. I'd like to find out if she ever did that, and then do the same for counts 2, 3, 4, and 5. All of them, you have to have intent. You have to have formulated a plan in your mind. They say it doesn't have to be like months or weeks or even hours, or it could be within a few minutes. You intend. This isn't like, oh, I encountered someone, so collateral or whatever, not thinking, and then go ahead and unalive. Want to know if anyone, hey, Sleuthy75, one of our members, thank you for being here. Hey, I want to know, did the defense serve discovery that said, turn over every bit of evidence that proves and that establishes every element of every one of the crimes that my client was charged with? I would like to see if they did that and what was turned over regarding entering the property. Remember the required ingredient, the required element of count 1 burglary. Was that asked for? Was it assumed? What were they going to turn over? Oh, phone pings, putting him in the neighborhood, putting him as far away as over by the Bed Bath & Beyond, where he was stopped that one time by the Latah County Sheriff's Department in August for $8 million. You would, and why is she fighting so hard to have her bills? That's not confidential. It's what you build, what you got paid for. That's what that is. We're not asking you what was your strategy, what was your discussions with Kohberger. It's what did you bill for your work? Why is that confidential? Why is she fighting so hard to have that come out? Good morning, all. Foxy Rose has entered the chat. So glad to see you. Again, everyone, please, if you haven't, hit the like. We got 122 likes. I appreciate that. But if you haven't had an opportunity, I do that a lot of times. I'll enter chat. I'll forget to like. And then, oh, gosh, I got to hit the like. Make sure you do that. That would be extremely helpful. Hey, Seahawks fan. Good to see you here. So, that's just basically where we're standing right now. We're at the very early stages of post-conviction relief. We have a very sketch count 1. Count 1. Count 1 is I'm calling, my opinion only, count 1's the foundation for the entire case. Count 1's the foundation of the entire case. And hey, Sleuthy, thank you so much for the super chat. I really appreciate it. Happy to catch you. Love to you too. Thanks for being a member of the channel. I keep saying, people say, oh, you got to The members of this channel have done more for me than I have ever done for them, because there have been times when I've said, what the heck am I doing here? You know, you spend hours upon hours upon hours upon hours of research, and you're wondering, is anybody listening? You know, is this value to anyone? But hey, William Tardy, a member for almost a year. Thank you. Thank you. I see you in discussions. I appreciate my members so much. They do more, and my work. I credit the members of my channel, people like Kathy Rutledge, who's followed me since when I had the podcast that started when the case started. I started to cover the case. I thought it would be done when he went to trial, and then the trial got postponed. He waived speedy trial. It was supposed to be in October of 23. Then it got rescheduled to 24. Early 20, supposed to be June of 24, Latah County. Then he got the motion to change venue approved. So now it's got to be set again. Then it's set for August of 25. Thinking, okay, this is the end. This is the end last summer. You know, I'm thinking, what other cases am I going to file? He's either going to be convicted or he's going to be, he's going to be not. That'll be the end of the case. And it's like 3.5 years. And here we are still. But it's my members that really motivate me to keep going sometimes. I'm like, is there really any value to this? I got to hope that there is. All these high-profile pre-trials lately, they're doing this for the money, itty-bitty poop, right? Thank you, Satire. Appreciate it. Again, positive reinforcement. I mean, the hypes that you guys do. I know Melba's here. She's done many hypes. Dan did a hype. I really appreciate that. It means a lot. It means a lot, guys. Good, bad, or wherever. Satire, that's what we're here for. Wherever, we've said this from the beginning. We're here to follow where the evidence leads us. I don't want any sabotaging, forcing, having a preconceived notion, and you look at the interviews and it's obvious that it was. It's just obvious in what we've seen. But, guys, I keep going back to Hitler alone. I don't know if Hitler went to University of Idaho Hemisphere. That's a great question. That was a great question. But we've been following. It's going to be 4 years since these tragedies occurred. 11/20. I began to follow the case. I wanted to follow the evidence. It was hard to follow the evidence because the evidence was sealed. So much of the evidence was sealed. Both sides, and it's not just the state of Idaho, it's defense as well. As a matter of fact, the defense is the one who drafted the non-dissemination, aka gag order, went to Bill Thompson, talking Miss Taylor, and said, hey, why don't you join us? Let's tell the judge that both sides want this, right? So we have a gag order. There were hearings some of them weren't even noticed. We found out about it afterwards, that they had hearings behind closed doors. So we know for sure, and we know for sure it meant many other important hearings, such as alternative perpetrator. I want to know. The Idaho State Police, early December 2022 through July of 25, they had suspect number 1. It wasn't Kohberger. Seems to me that's an alternative perpetrator. Hey, judge, don't take my word for it. We got the Idaho State Police over here, integrally involved in the case. From 12:22 a.m. on the November 13th. That's when ISP got the call to come out to do the crime scene processing. Then they got involved with doing multiple interviews. They processed the evidence that the MPD sent them. And when you look at what ISP tested, it's not like the ISP, well, let's take this swab, let's take that swab. No. It's what the MPD submitted to the Idaho State Police, because the MPD is the client. William Tardy, thank you so much. Seeker of the Isles of Shoals, thank you so much. seeker of the truth. I'm glad that a couple of people have liked that. I know you are. Based on Just Jackie is with us also, but thank you, Isle of Shoals, and thank you to the people who like that. We're all here. We want the truth, whatever it is. If it's Mr. Kohberger's a scapegoat, if Mr. Kohberger was an accessory before, after the fact, co-conspirator, alternative, whatever. If he was not involved at all, if it's these other people, what I'm convinced of is there's no way one person committed these crimes. I will never believe that. Hey, Soul Sister Forever, good to see you here. Another one of our members. Thanks for being here. I will never, not, they did not release that autopsy report until just recently, right? Any other case, that would have come out much sooner. You look at that autopsy report and you put 2 and 2 and you say, how does one person commit these crimes in a matter of minutes? Okay, let's go over the timeline again, because this timeline is so confusing to me. According to the PCA, suspect vehicle 1 is last seen on camera at 4:07. So suspect vehicle 1, if it's got to pull behind the 500 Queen Apartments and park in the back of 1122 or on the side, that little road, that goes down between, separates the Queen Apartments and 1122. Going to take a few seconds from the last time it's seen on camera at the Linda Lane camera, 4:07 a.m. Got to drive behind the apartments, got to park, got to get out of the car, shut the car down, got to go up to the back slider if that's what the point of entry was. What time's that? What is it, 4:08, 4:09 by that point? And then on the way out, to be seen on the 1112 camera at 4:20. That tells us that there needed to be a few minutes beforehand. Ends the crimes, leaves the house, walks back up to the car, opens the door, gets in, shuts the door, turns on the engine, and takes off. So what's that, 4:18, 4:19? So what are we talking about? Maybe 5, 6, 7 minutes here? Committed all those crimes? Look at how many blows Xana took. Look at how many blows Kaylee took. And they're saying that there are pics, there's injuries that don't appear possibly to be consistent with a K-bar. So it's at least 2 weapons. What? You're holding the K-bar in one hand, you're holding a pick in another hand, or whatever. You're holding down Maddie, you're holding down with 2 girls fighting. And then even more ridiculous, and then go into what happened in Xana and Ethan's room. Ethan's in bed. Xana's supposedly up, having been chased across the hall. You saw that the furniture being pushed and moved. Apparently Ethan slept through it, or if he got up, he just stays in bed and does nothing as his girlfriend's being attacked. And then what? Or alternatively, and this is what Turvey sort of said, couldn't have been 2 people, it couldn't have been 1 person. What's he do? He then, let's just say he decides he's got to eliminate the 6'3" athlete, the 20-year-old. He goes to Ethan, and what's Xana do? Xana doesn't jump on his back. Xana doesn't scream. Xana doesn't run out of the room. Xana doesn't call 911. She just stands there and waits for the sole perpetrator to finish with Ethan and then turn to her. And where are the footprints out of the room? You saw the condition of that floor. And how come there wasn't any transfer? If Maddie was first and then turns to Kaylee and then Xana and then Ethan, why doesn't Kaylee have Madison's red DNA on her? Why doesn't Xana have Kaylee and Madison's DNA on her? And why doesn't Ethan have Kaylee, Xana, and Maddie's DNA on him? There should have been a mixture. I didn't see anything like that. BK has superpowers. Do you remember the rumors? Do you remember after he was arrested, we're like, well, we didn't see any like red DNA stains on the back patio, like that slab, that white slab of patio. What did he do? Did he pogo his way out? What, did a helicopter come down over 1122 and let him down, and he gets on the patio and he lets himself in on the third floor. But Payne says the crimes continued to 425. Well, if BK is the sole defendant and he's seen speeding out of the neighborhood at a high rate of speed at 420 on the 1112 camera, who the heck's still in the house for the next 5 minutes committing crimes until 425? It certainly can't be BK. Or is suspect vehicle 1 driving itself home, and then BK is still in the house until 425? And what's he do? Does he call the private driver to come pick him up and take him home? Montana Lil, good to see you. Thanks for being here. Tomboy Char, don't even get me started on the beer pong table. Shaking my head. Levitated, I guess so, Soul Sister. He's got to have, apparently he's got kryptonite for something. Whatever clothing he had was kryptonite. DNA was scared to get on him. There wasn't a speck of any of the victims' DNA in the car. When that car came back clean, and it was torn apart twice. The feds did it and the ISP did it. And when they go into the floorboards with like this vacuum type of apparatus to try to find DNA down in the floorboards, they found nothing. What did he have? Did whatever he got from the Walmart or whatever, his overalls, was it kryptonite that the DNA? Oh, no, we can't go near him. We can't attach ourselves onto him. We're scared because it's kryptonite there. No, we can't attach ourselves. Come on. Leslie, it's true, Leslie. KG, gorgeous smile. You think that she was the target? I've gone through every single one of those of those victims as being the target, every one of them. And I've gone through, they were all targeted for different reasons, or the house was targeted. Everything that they said, remember at the beginning, all the confusion at the beginning of the case? You had the coroner saying one thing, Thompson saying something else. The mayor comes out and says it was the house that was targeted. No, it wasn't the house. It was one of the victims. Oh, no. It was all 4. Oh, it was the victims. And it's like, you can't get a straight story out of these people from day one. Okay, Secura is, I think I read this, that Hitler did graduate from the University of Utah College of Law in 91. And he worked on civil and felony criminal county, presides over Ada County Mental Health Court Program. He's also the administrative judge, which is why it's so important that this amended petition is as perfect as it can be, because Hitler loves those administrative rules, and he has slapped both sides on the wrist in the past for not complying with the administrative rules. Tomboy charm, Payne and his misleading of items should have been a huge red flag. What about the 2 different phones that he cites as being tracked? The 8458, it was area code 509, and then I'm not going to give the next 3 numbers, and then 8458 was the phone number that they tracked to BK that they got off the documentation for when he was ticketed back in August. But then there's 509 ending with 8548 that was mentioned also in the PCA. That happens to belong to the chief of police of WSU LE, who happened to interview Kohberger for a position in law enforcement as an intern that he didn't get. But Kohberger also, per Payne, told him during the interview that he was at that time working on projects for 2 law enforcement agencies, Pullman and WSU LE. So why do we have the chief of police for WSU LE's cell phone 8548 cited in the PCA not once but twice when Payne's talking about tracking the perpetrator? Nobody can answer that question. Conflicting stories at the gate made it almost impossible to differentiate. Oh, yes. So I mean, it was a precedent that was established from moment one, and it's just never stopped. Someone in some place, we don't know. We would, do you know if the sheath was actually found on the floor? We would need to see. In my opinion, that question can only be answered by an unsealing of Officer Nunez, and also I would say to Warner, the first and second MPD officers who went into that third floor room. What does their body cam show? I will tell you that Warner, that room's tiny, right? Madison's room's not really big. It's not big. She had that double bed. She had some furniture. It's not a big room. There's not a lot of space in there. But he got close enough to Maddie to know. Remember, her leg was hanging over. He noted lividity. That's where the blood starts to flow. When the heart stops pumping, it's a physiological condition that happens to the body. So he's noticing that on her leg. The sheet's supposed to be right there under her leg, right, or under her hip. Can it be possible that he didn't see the sheath? He didn't mention it. You don't hear him talking about the sheath at any time during the day. You don't hear anybody going into the evening talking about the sheath. Anybody. You don't have, and none of the first 5 responders mentioned the sheath in their reports. Not Nunez, not Warner, not Gunderson, not Smith, not Snyder. Snyder certainly didn't mention it when he's going through the third floor and taking photographs from his iPhone as he did it. 12:25. Hello. He's going into that room and taking photos. You would expect that there would have been, we haven't seen the photos from that room, but you would expect what we've seen in his report, his descriptions of what, photo number, whatever. This was of the kitchen, the fingerprints, and photo number, whatever, was up on the third floor in Kaylee's room, and bathroom, third floor, to the right, to the left. You would have expected to see 10, 20 descriptions of the sheath that he would have taken a photograph of when he went into that little room, and he's taking photographs of the victims. He's taking photographs of everything in that room. I would have expected to see 10 the sheet from above, the sheet from the right, the sheet from the doorway, the sheet from the left, the sheet from underneath, the sheet standing close to the bed. None, not one. Everybody missed the sheath. In part of the country where people hunt. K-bars, people walk around with K-bars, from what we've been able to find out. They have axe throwing contests. I think they could happen that same night. But you have all of these officers, all the people in that house, and nobody mentions the sheet hanging around out front in the evening. It's not mentioned. It's not in anybody's reports. How's that possible? Penn Dizzy, 100% Kathy. It looked pretty pristine. In some place, it didn't have any red DNA on it. It looked pretty pristine, considering where it supposedly was found. Penn Dizzy is declaring MPD are lying arse joke clowns. Yes, Yvonne. Like I say, if you haven't had a chance to look at our playlist, check out 3 Days in Moscow. It's about, I think, 6 episodes. It takes you through the 3 days that sheet spent in Moscow before it was finally taken to the Idaho State Police. And again, it's not the Idaho State Police going and grabbing the sheet. It's because the MPD wanted it tested. The MPD is who decides what gets tested and what doesn't get tested. Yep, Tomboy Sheath. Talbot's written report said the sheath was on the floor. I think it was his handwritten notes, because his report said the sheath was on Maddie's left side, as opposed to the other one, Payne, who said it was on her right side. But then in the handwritten reports, it's on the ground. It's like all over the place. Come on. I honestly don't know if they're prepared to hear the truth, but I think it's going to be 10 times worse than the law. Saul, sister, yeah, there's, I think that the world needs to be prepared for whatever it is that comes out, assuming that this trial happens and assuming that they do uncover the case and don't keep, working as hard as the dickens to keep this case sealed, not just in Idaho versus Kohberger, but also EWU media. Moscow and Moscow police have been fighting like heck to not release things to EWU media on those public records requests. By the way, there's no ruling yet. The last thing that happened, August 5th, there was the oral argument before Judge Marshall, who's presiding over that public records lawsuit. We're waiting for a ruling to come down. As soon as it happens, you will. I surely hope that she directs Moscow and MPD to turn over some of that evidence that was withheld, or to stop redacting so much. Those are the two things. They said that certain things was not produced to them. Other things were overly redacted. Roxy Rose, behind you. Very good. Very good, Foxy. Thank you. Isles of Shoals, going back to that very early quandary of a quote. I told Adam everything. What does that mean? Satire, every wound represents each time the perp could have shed. Yes, every stain. And he went for a physical that week. And satire, I want to pose this question to you as we welcome AGA Pluff. Thank you to the chat. Satire. We saw video of BK in the Albertsons walking around. This is several hours later, during the daytime hours of the 13th, around noon. Having been through this ferocious fight, throwing all of these wounds, fighting with Xana, running up and down stairs, going around pong tables, doing everything that he did, wouldn't you have expected him to be bent over in pain? No, he's walking like he had a good night's sleep the night before. And then he proceeds to go for a physical a couple days later, when everyone in the area is talking about these crimes at 1122 King Road and the 4 Idaho students. And you're telling me that his doctor, the staff, anyone that came into contact with him didn't see a mark on him, didn't see a bruise, a wound. The people who he interacted with at that university, WSU, didn't note that he was walking around bent over in pain. He had cuts, he had bruises, nothing. What does that tell you? Tomboy Charm, no, I did not have a chance yet. Records, that fiasco from Connor, an accomplished day. Is it something that I should look at, Tomboy Charm? Callie's saying best case scenario, ISP, MPD, and point fingers at each other and BK goes free. Yvonne, there's always this very slim possibility that PCR is granted, the state would choose to drop. Yeah, they can do that. They can drop charges. One of the remedies that Judge Hippler could also do is dismiss the charges. He can do that on PCR. He can grant that relief. Let's see what happens. Montana Lil, I believe that there should have been a change of state as well. Zero. Okay, you agree with me, Soul Sister? I know you've been following this case from the beginning. You've seen the videos. You've seen the photos of him. Did you see a bruise, anything on him? Did you see him walking around as though he had been through a ferocious fight with Xana and all of the other injuries that he alone, as he's running up and down steps hours earlier? I would have expected he would have been bent over like a fighter who just came out of a fight that the night before. Nothing. He's walking around like he's fine. 150 wounds, 150. Just the exertion alone on your arm, back and forth. And this isn't like if this was by firearm, completely different story. Number one, we would have expected him. He should have been covered with red DNA. Covered. Which he wasn't, because it would have been in the car and it would have been in his house. They found nothing. 0 injuries. Soul Sister. 0 injuries. 150 wounds. I think that the weapon would have slipped at least once and caught the person. You're so clumsy that you're dropping the sheath, but you're perfectly agile for 150 reflections back and forth. You're perfect then. But you dropped a sheath. You're not perfect there. Yes, there are reportedly 2 different systems that the docs. Oh, so MPD is only searching one system. Oh, I got it. Thank you, Tomboy Charm. I will put that on my list to look at. Thank you for bringing that to my attention. BK needs to be found not guilty. The misinformation public will crucify him if it's just dismissed. He needs a very public trial, is what Montana L is saying. No, he didn't. Trial would then show all the evidence to Montana L, right? And not Leslie, that's what did it for me. Leslie, that's what did it for me. When his car came back after learning that it had been processed twice, Leslie, twice it was processed. Feds, ISP, they didn't find a drop of DNA in his car. Nothing. Lady Spedwell, outrageous. 0 zip. Yeah, nothing. Come on, Penzizzi, come on. What more is the public supposed to accept out of this case? Why are they not unsealing the case? Why did Judge Hippler stop months ago, basically unsealing the case? Lady Speedwell is saying, as a UK citizen, our media here needs to be informed of the findings. Spread the truth far. Yes, absolutely. We have citizens of the world who have invested their time, their energy in this case. And yes, you deserve an explanation. I agree. Public trial. Soul Sisters is agreeing that a public trial is necessary. You must see what they've got, or more importantly, what they lack. No more behind closed doors. This case was run like it was an inquest into what happened to President Kennedy, November 22nd, 1963, of national public security. This is a state unaliving case. There are trials that happen every week across the country, state unaliving cases. They are not sealed like this one was. What does that tell us? Brian needs a trial, or they will say he got off on a technicality, is what Yvonne's saying. So I guess that most people are believing in chat today that a trial is necessary. All right, guys, I think that we've been going now. Oh my gosh, it's almost 2 hours. I've never done a live this long, but it's a lot to discuss today. If you haven't hit the like button, please do us a favor and hit the like button. If you haven't subscribed to the channel, and hit the notifications button, please subscribe to the channel. Hey, Kimberly, 007, so glad to see that you made it. So glad to see that you're here. We're going to have this up on replay so that you can listen to it. Oh, Foxy Rose has said that this is horse doo-doo. This case is horse doo-doo. But hit the like button, hit the subscribe if you're interested in becoming a member. Not necessary, but we do love our members and appreciate our members for everything that they're doing here for me and supporting the channel and supporting the content. I'm going to have some surprise findings for you that are in development right now. You're very welcome, Soul. Thank you very much for being a member of the channel. Stay tuned. Hit the subscribe button, hit the notifications button, and we'll be doing a little bit more. Oh, Rebecca Pardue, one of our members, just got here. Well, my arm got twisted. I'm going to have to go a little bit longer for Rebecca because we love our members. It's the last thing I could do. Oh, Lady Speedwell, the Netflix stock is #1 in the UK. The world is being fed lies. Absolutely. Works of fiction. What about the Howard Bloom? Satire, member of our channel. Thank you so much. What about the Howard Bloom work of fiction? I call it fan fiction. He purports to, he knows what's in Kohberger's head as he's driving around. He's sitting in the front seat between Kohberger and his father as they're driving across the country. What about the Dateline episode? I don't think in that Dateline episode I heard one time that a person is considered not guilty under our judicial system and our Constitution until or unless they plead guilty or adjudicated guilty. It was a complete hit piece from beginning till end. And I, for one, cannot imagine that they don't know who did it. We got some whispers from Chervy that they do know who did it. And he's saying it wasn't him. What did Judge Stephen J. Hippler say? Look at the document hold order that he put out. May 15th, 25. It was the date of the final pretrial conference. He stated at the final pretrial conference that 2 orders were going out, one to the defense, one to the state. And if you read paragraph 1 of the document hold order that Hippler put out, it said his concern about this dateline leak, it had information that was never intended to be seen, that was under seal per a gag order, and that in his opinion, he believed. This is Judge Hippler saying this now, not me. Not me. This is Judge Stephen J. Hippler, the trier of the law, in fact, in Idaho versus Kohberger. He said he thought that a member of the prosecution team or current or former law enforcement is who gave the information to Dateline. And he said this troubled him because, number one, it made seating an impartial jury more difficult. That is due process. That's the 14th Amendment, Mr. Kohberger's constitutional right to an impartial jury. That is a 14th Amendment privilege. Judge Hippler was concerned about the ability to do that. And he said he felt that it was a member, not defense, but the law enforcement, current, former, or the prosecution. And he said that troubled him because these are people that are in place to uphold the law, possibly. Who is the leak, Judge Hippler? Who is the leak? The public has a right to know. So we're going to say now Howard Blum. Oh, okay. Now he's saying that the timeline does not work based on FOIA evidence, which he did not have when he wrote the book. Well, then why write the book when you did, Blum? Why not do like everybody else does and wait until the trial's done or he pleads guilty and then write the book? That's the problem. But you know what? The damage that was done by his book is done. It's done. How do we go back and erase that? Now he wants to come out with another. And how do we know that that's not going to be wrong if he was wrong the first time? With, as I call it, fan fiction. That's my opinion. Rebecca's saying, does it mean that SR, if he thinks it came from, I don't know. Hey, says, Judge, this is Judge Hippler. Rebecca, please take the document hold order. I've done a few episodes where I pulled it up, but I mean, you can go on the docket, pull it up. May 15th, look at the one. He did 2 of them. Look at the one that he wrote for the defense. Look at the one that he wrote for the state. It's in the language that you want to see, paragraph 1. Hey, Sarge is in the house. Money, 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 money. Sarge, have you seen my research on count 1? And if this is a gift to Mr. Kohberger going into post-conviction relief. If you haven't, I hope that you will. If anyone has not checked out Sarge Friday's channel, please do. I think we also had Christy Chaos in here. We got Truth Seekers. Sarge is doing a great job looking at the spatter, looking at the crime scene, trying to reconstruct it based on evidence. Foxy Rose saying, yeah. Soul Sister, what, right? And I'm still in shock at victim impact. Oh, hey, maybe that's a Soul Sister. Now you got my mind working. I'm wondering if that's the reason why they want the transcript to talk about the debacle. Hippler lost. I said it during the time of the final pretrial conference. I said it afterwards. He lost control. Now, I know that they give, when there are victims there, that it's sensitive. It's difficult for them. They're getting emotional. People are applauding, they're cursing, where they're threatening him, where they're calling him a child M as he's getting ready to go to prison, where they hate them. They hate them. Why? To make him a target? He wasn't brought up on charges of being a child M. He's sitting there dabbing his eyes. Hey, dude, if you're too emotional, call a recess and get back in here when you're in control of your emotions and take control of that courtroom. I wonder if maybe that's what Rouse wants. He wants to be able to point to the docket where sentencing totally was out of control. You don't curse in a courtroom. You don't. You don't threaten anyone. You don't call someone who's getting ready to go into prison who is never brought up on charges of being a child M when you know that prisoners hate child and would make him a target more so than he is because he's high profile. Maybe that's what Rauch is looking at, guys. I don't know. Maybe. Penn Dizzy, Blum is a bum. Definitely so. I thought he did. Maybe that's lost control of that courtroom. Maybe that's what they want to drop in, because what they need the transcript to drop it into the amended petition for post-conviction relief, not just for Hitler, but also on appeal. Especially, Yvonne, I agree with you. It was like Jerry Springer. Good point. And we got Jerry Springer Ray saying he can track Brian inside the house. Yeah. Next thing we're going to hear, Kyle. This is Mr. Kohberger's partial alibi defendant who was going to get up in front of the jury and say, "Jury, you got to find him not guilty because he wasn't there. Here's his alibi." All right. And we have a very performative. I couldn't watch her. Yeah, it really was. I mean, you're in a courtroom. This is a serious proceeding. You have the victims. You have family members. You got the world watching. It is deserving. This is our judicial process. This is our Constitution working. Let's have some respect for the people who have given their lives over the years, starting with those who fought in the Independence War, so that we could have these freedoms. Let's show them a little bit of respect in how that courtroom proceeding went. Maybe that, because he also wanted the recording. Remember, he asked for the recording too. Now, yes, we can get the recording. It is out there, but he wanted a recording from the state. I'm thinking that may be what he's wanting to drop in there. Of course, we'll find out. That's pure speculation on my part. Oh, they turned it into a joke. An absolute sideshow is what the Holly Berry UK, one of our members, feels. Yeah, I said to myself, when I saw Hitler he's dabbing his eyes and this, that, and the other thing, I said, Judge Hitler, you need to take a break if you're too emotional, and you got to stop these people. Here's another thought. If count one goes away, they can't place him in the house. Guess who's no longer victims? The two surviving roommates. They're victims because they were the victims of the burglary. Right? They weren't harmed. So they're no longer victims if count one goes away. And for those of you that are coming in late, listen on replay to this. We've talked it out on chat, but we also take a look at our last video that we put out. Hey, Mrs. Jim Morrison entering the arena. Good to see you. Make sure you hit that like, guys. Oh, gosh, we got 158 likes. That's wonderful. Wonderful, wonderful. The last 24, the mic playing that roll through. Yep. Kara gave a good statement as a parent of Xana's grandmother, too. Xana's grandmother, too. I had a lot of respect for Xana's family. Her father, mother, and I think it's her grandmother, one of her grandparents. Lady Speedwell, she seems to have suggested as much. Kara absolutely knows it. But of course, she's been gaslit, out the window, because a lot of people, they get involved in something. They get involved. They fall on hard times, and you don't know how to get your way out. I've had members of my family, who have, and so they gaslit her. That's what I feel happened with Kara. Count one goes away. Written Dreams wants to see count one. Hey, let's go back. Let's look at the ingredients of the cake again. All right, 1401, burglary defined. Every person, element one or ingredient one, who enters any house, element two or ingredient number two, with intention to commit, element 3 and 4, any theft or felony is guilty of burglary. What evidence they have that he entered that house? What evidence did they have when he took out that criminal complaint back on the 29th of December And when he went before that grand jury, element is missing. If you don't have all the elements, just like all of the ingredients for chocolate cake, you don't have the crime of burglary. Burglary goes away. The two roommates are not victims. They're witnesses maybe, but they're not victims. Yeah, rating Rebecca Maddie's grandma made me cry. That's what a victim impact should be. Remembering the victim. She was dignified. She showed some empathy. You know, she's, I think, a God-fearing person who showed empathy. Even she said, look, Brian, if you want to, at some point down the line, I'm here to listen. The Hollyberry UK believes that Kara knows what's going on. In my opinion, they all do. It's just some don't want to see it. Well, we're going to find out. Yeah, they blamed her lifestyle. It's heartbreaking. Itty bitty. She looked great at sentencing, I thought. I mean, what about the sheer and utter inhumanity of, in my opinion, of mainstream media doing an interview of her in the condition that she was shortly after she lost her daughter in a car. I think that we saw who she really was at sentencing. The lady deserves respect, just like any other mother. She gave birth to Zach. If you've given birth, you know what that means. Carrying around this other human, nurturing for 9 months. It's not a joke. And in my opinion, she's been treated as a second-class citizen. That's just my opinion. Jim, I mentioned this in Andrew Meyer's video, that the fact he signed the plea before Thompson read the facts into evidence, could Hitler have reversed the deal? Yeah, anytime. You know, Hitler had the ability to say, hey, wait a second, let's look into this. I have a concern here. We got a key element of the crime that apparently never existed. He just pled guilty to a non-crime. You know, I agree with you too. So MSN. I mean, when they did that video of her, it just broke my heart. It broke my heart. Many of us, who are we? Anybody? Many of us have stumbled. Who are we to point the finger at anyone else? What is that old saying? Don't judge anyone until you walk a mile in their moccasins. And she seems like just a person that's very easy to take advantage of. She has no power. Gaslit. Hey, Larry, good to see you here. Good to see you here. Yeah, Holly, the plea should have never gone through. I think there should have been an objection when Thompson admitted what he did. I think that Judge Hitler should have stopped everything and investigated two things. Both the fact that there's necessary element of the crime of burglary that didn't happen. And secondly, having BK, taking the time to have BK evaluated by a physician, psychologist, psychiatrist, to ensure that he knew what he was doing and that this was truly willing. And this is even before we learned all about this coerced business, about, you know, bringing his family in, and really you bring the deal, you explain what the dangers are, and then that's it. You don't go back 20 times and continue to put pressure on someone. Okay, guys, it's our constant. Yes, this is our constant. Bottom line, I want to, Colin, this is our Constitution not working, I think, and we owe it to those people who gave their lives going back to the Independence War to give us these freedoms, these gifts that we have and that we enjoy, and to make sure that they're not being abused by people who are in a position of power to abuse it. All right, everybody, we're over 2:08. I've never done a live this long. This was really, I think, important topics. I've appreciated your commentary, your opinions. You all deserve respect for your opinions. Please continue to share your opinions on the videos. That's what they're there for. It's to exchange thoughts like our country is set up to do. We're here to express ourselves, to talk about important events, and this case is extremely important. in terms of our Constitution, and to find out what truly happened on that dark day, November 13th, almost 4 years ago. All right. Thank you. Oh, my pleasure. Thank you all. Thanks for being here. We'll have this up for replay. Please hit the like on the way out if you haven't already. Comment on the live afterwards if you would like to. Subscribe to the channel and hit the notifications. All right, guys, we'll be doing some more of these now that we're in the early stages of the post-conviction relief action in Kohberger versus Idaho. Thank you, Soul Sister. Thank you, everyone. Enjoy the rest of your day, evening, morning, whatever it is, wherever you are. And until next time, this is Kathy. Thanks for being here today, everyone, for our podcast. Bye now.